Hey y'all, it's your girl, Attorney Simone at Girl, Is That Legal? Hold on a second, we got to make this adjustment. Thank you guys for joining. It's your legal bestie. Oh, great. As you guys come on in, hit that like button. All right, we've got Diddy's on the docket for today. And I want to let you guys know, we're going to talk about two elements of the Diddy case. Number one is that baby Tony Buzbee, the Houston lawyer who filed who has 120 plaintiffs that are going to be suing Diddy, has been sued for extortion. We're going to talk about that. And we are going to talk about Diddy's latest motion filing from his attorneys that are claiming that the government has unlawfully seized documents that belong to Diddy that are part of attorney-work-client privilege. And ultimately, they could be seeking a mistrial and a legal advantage. So we're going to talk about those two things. So you guys, let me know where you are joining in from. Yes. I said not daddy's lawyers. Daddy's lawyers. Yes. Good evening, y'all. Oh, I also need you guys to peer pressure me. I have been overthinking my story times that I have for you guys. So I need y'all to peer pressure me in the comments and be like, where is the story time you promised us? Because I have multiple. One of them, of course, is that's how my boyfriend called the cops on me. He is a terrible person, but I'm going to tell you that story. Another one is probably the time I was in love with the international drug lord. That was a good one too. Statute of limitations has officially passed, so I can now tell that story without anybody getting locked up. Won't let me out. If you've not tuned into this channel before, I am attorney Simone Redwine. Ooh, my hair. And I am a real lawyer. Yes. I practice, I practice primarily injury law, but I also do legal strategy. And so if you would like to, here we go. If you'd like to schedule a consultation with me, you can do so by going to my website, which is simoneredwine.com. You can hit on the top right corner, you can hit book Simone, book or hire Simone. And I have consultations that start at just $149. I help people with legal matters throughout the nation. And you can also get my book, which is called Background Checks 101, the beginner's guide. It's an ebook, beginner's guide to discovering who the heck you're actually dealing with. So I literally teach you how to do background checks on people you're dating. It could be your brother's girlfriend. It could be, anyone like that. You can do that. It's $19.99. And when you purchase it, the thank you link that comes right after you purchase it has a download link for you to get the book. Hit that like button, guys. All right. So first up, we're going to talk about this extortion lawsuit. I knew it was coming. See, this is the strategy. I've been sued for extortion before. See, when you get sued for extortion, it's usually, by you, I mean lawyers. Usually when that happens, now there is Michael Avenatti, whatever his name was. He got sued because it was related to the Donald Trump case, right? But usually what it is, it's to silence attorneys who were whooping that tail. I was suing a corporation who made a very dangerous product. The corporation had received $5 million from Jerry Jones and was trying to be publicly traded on NASDAQ. And I discovered that the product that was supposed to be life-saving was actually deadly. So they claimed my demand letter to resolve the claim was extortion. And they did that to try and silence me. At the time, I literally had just gone out and really opened my own firm. I need something to drink. Here we go. And open my own firm. And so they try to do that. So this is not unusual. I actually expected Diddy's lawyers. I thought Diddy's lawyers would have been sued, one of these attorneys, for extortion. I thought actually that it was going to be Tyrone Blackburn to get sued, not because he's done anything wrong, but because that's frequently a strategy. So I'm going to read you the article on this from TMZ, and then I'm going to break it down for you. So it says a prominent figure is suing the lawyer representing more than 120 of Diddy's alleged victims, saying the attorney is, quote, shamelessly attempting to extort exorbitant sums from him while threatening a lawsuit packed with wildly false, horrific allegations if he doesn't pay up. Well, we've seen in Buzbee's lawsuits, I think right now there's like 8 or 10 that have filed. That's exactly what he does. He is claiming, Buzbee has said on the news that his position is if you are rich and famous and you were there and you didn't stop what was happening, then he's going to sue you. He's going to sue you. Okay. So I'm going to comment on that, but I'm going to keep reading. It says the plaintiff, identified only as John Doe, filed his own lawsuit in LA County Superior Court Monday morning, describing himself as a high-profile individual who knew Diddy and attended events along with the mogul. He's being repped by one of the premier law firms in the country, Quinn Emanuel. Let me tell you this. Quinn Emanuel's partners bill at $3,000 an hour. This ain't no contingency fee case. That means this person, their reputation and their brand is worth at least $3 million, because that's what they're paying these lawyers to bring and fight this lawsuit. And this is going to be one that's going to have to probably go all the way to trial because of the fact that Buzbee's not going back down. Now, the man says attorney Tony Buzbee and his firm threatened to unleash entirely fabricated and malicious allegations of assault, including multiple incidents of assault of a minor, both male and female, against the plaintiff if he refuses to comply with their demands. The suit goes on to say Buzbee's demand letters allege the plaintiff assaulted males and females while they were under the influence at parties hosted by Diddy's. The plaintiff references past lawsuits that Buzbee has filed against other celebs, including football star Deshaun Watson. The man claims Buzbee tried to shake down Watson and others, making dubious claims that he knows would not stand up in court. Now, I agree. Oh boy, Deshaun Watson, that was a shakedown. The reason I say that is it was Deshaun Watson's case was involving him going to massage parlors and asking for happy endings. That actually happens quite frequently. He asked for happy endings. When the girl said no, he went on about his business. I don't think that should be a crime. I want you to ask me if you want me to touch your Peter. Ask me to touch your Peter. I say no and go on about your business. That's what I want to occur. And if you do that, I don't think that I should be able to be awarded cash. Now, if I say no, and then you go and try to get me fired, then we got a whole nother problem. That's not what happened here. The gist of the facts was that he went around asking a bunch of people to stroke his Peter, and some said yes and some said no, but that was supposed to be crime. Okay, I digress. Sidebar. There we go. It says, furthermore here, the lawsuit, yes, 3,000 hours, what that other firm said. It said the lawsuit obtained by TMZ goes on to claim Buzbee did the same thing, as in the threats of extortion and embarrassment against Green Bay Packers kicker Brandon McManus, allegedly threatening to sue over specious allegations of assault. The suit claims the NFL investigated and found insufficient evidence and closed the case. Same thing happened with Deshaun Watson the first go round. They looked into it and they were like, okay, they closed the case. But I think with Deshaun, they did give him some form of suspension, but that was in part because it was just so many people saying the same exact thing. It was literally the same lawsuit filed like 32 times. It said the suit claims the NFL investigated and found insufficient evidence and closed the case. The new lawsuit filed by John Doe references the TMZ documentary. Buzbee appeared. Ooh, these pictures. Somebody ain't got no shirt on. Oh my, I think that's a lady and another lady. Oh my gosh. Buzbee appeared on TMZ's new documentary, The Downfall of Diddy Inside the Freak-Offs, in which Harvey asked him about the criticism that Buzbee's MO is that his modus operandi, basically the way he litigates cases, is to put enough embarrassing info into a demand letter that it forces a settlement. Buzbee acknowledged that that indeed is the game, saying it's just the way the system works. So here's my question for y'all. Do y'all think that's fair? Do you think it's fair that he is able, as a lawyer, it is within the bounds of what you can do. You can send someone a demand letter and says, and say, you were at this event, you did you were here, and we're claiming you did these things. And if you pay up, or if you're willing, here, all he said is if you're willing to go to mediation. Now, the assumption is if you go to mediation, it's going to be meaningful. If you resolve it in mediation, it stays confidential. If you don't, then they're going to file a lawsuit. And here it further says the lawsuit claims Buzbee put a ticking clock on the extortion demands. It's ready to sue if the plaintiff didn't agree to mediation to, quote, resolve this delicate and important matter. The plaintiff is suing for extortion and intentional infliction of emotional distress. Check this part out. It says the law firm, that $3,000 an hour law firm, Quinn Emanuel, urges anyone with information on Mr. Buzbee to contact the company via the email openline@QuinnEmanuel.com. So, because remember, Buzbee had created a hotline for people to call them who felt that they had been victims of Diddy. So now this firm is like, no, if you've been a victim of Tony Buzbee, in other words, if you feel that someone from his firm has tried to coerce you to say something that wasn't true, or to file a lawsuit that you felt like maybe wasn't warranted, whatever like that, that's what they're trying to do that. Now, oh, don't forget to hit that like button. Yes. So here, what the issue is, let me go on back. So what the issue is in this lawsuit, and this is a lawsuit that is going to fight to the finish. Now, what's interesting is the plaintiff in this case has filed himself as John Doe. Well, Mr. Buzbee has filed every lawsuit that he's filed as Jane Doe or John Doe. Now he don't like it though. He don't like it. He said he's going to file a motion to make this person out themselves. I don't know that the court is going to require it, and here's why. First of all, this case is in LA County. LA County is very liberal. And if the core of the lawsuit is that you are here trying to extort and embarrass me, if the court makes him out his identity, then Buzbee wins. He's now been outed and embarrassed. So I think that the court is it'll be interesting to see if the court lets him stay anonymous. If they don't, that's a lose right there. Or what they could do is say, no, by this date, you have to refile with your identity. And then that person can choose to completely dismiss the lawsuit so that their identity actually never would become public. But one of my questions, what I'm wondering about is, I wonder if this person that filed this lawsuit is the same person that attorney Ariel Mitchell Kidd said was on the video that she saw with Diddy. Because remember, she said there was this video and she was selling it. It included some rich, famous person that she said was even more famous than Diddy, that she offered to sell it to this person, but that the person wasn't buying, that it was going to be a catch and kill. It makes me wonder if this might be the same person, because now they're like, oh, heck, I'm getting it both ways. Let me go ahead and file this lawsuit. Because when Ariel Mitchell Kidd was telling that first story about how, everyone was like, isn't this extortion? Everyone thought it was extortion, including myself. I had serious concerns about a lawyer going to a victim and saying, hey, I got this video of you that I don't think you even know you're being videoed. I don't think you consented to, but if you give me $1 million, I'll give it to you. That's concerning. But more than that, when I thought about it, I was like, well, why doesn't this person sue Diddy or sue her for doing it? I think because it would be too obvious. It would be way too obvious that anyone suing her, they would know that that's the person in the video. However, by suing Buzbee, it doesn't create that correlation. So yeah, it's a Kenny Black, great point. It said, is a thin veil of offer versus extortion. Now, what Buzbee is saying, let me go to his page. Hold on. What Buzbee is claiming is that he hasn't done anything wrong. He said, here we go. I'm going to put his statement up. Is this the one for today? Yes. All right. What Buzbee says is, I've been sued in Los Angeles as a last-ditch attempt to stop me from revealing names in public lawsuits. It won't work. The irony? The suit against me was filed by a powerful John Doe. Here's my full statement. We won't allow the powerful and their high dollar lawyers to intimidate or silence assault survivors. It's been reported that a lawsuit has been filed against my firm claiming extortion. The lawyers that filed it also immediately called TMZ in an apparent effort to silence those who alleged assault. Here's the deal. The case filed against my firm is not only without legal merit, it's laughable. Here's why. On behalf of two clients who alleged assault, we sent a standard demand letter to a New York lawyer that we know represents an alleged perpetrator and potential defendant. The letters were sent seeking a confidential mediation in lieu of a lawsuit. No amount of money was included in the demand letters. No threats were made. The demand letters sent are no different than the ones routinely sent by lawyers across the country in all types of cases. It's obvious that the frivolous lawsuit filed against my firm is an aggressive attempt to intimidate or silence me and ultimately my clients. The effort is a gross miscalculation. I am a U.S. Marine. I won't be silenced or intimidated, and neither will my clients. Since our professional efforts at resolution obviously have failed, we will instead disclose the demand letters that we sent at the time we file suit. That means he's going to sue this person and reveal their identity. Hot dog. It says abuse of the legal system unfortunately runs rampant. The lawsuit filed against my firm is a prime example of that. Sunlight is the best disinfectant. Sunlight is the best disinfection. That's interesting. I have confidence that with full public discourse, all of this will sort itself out. Tony Buzbee. All right. So this is basically what's going on if you're joining us now. Tony Buzbee has been sued. Tony Buzbee is a lawyer that that did the press conference. He's got like 120 clients who claim to all be victims of Diddy. He's filed multiple lawsuits already. Well, he has now been sued by a very famous person who is claiming extortion, that he tried to extort them by basically saying, if you settle with us, your identity won't become public. And Buzbee's position is, hey, that's just how it works. That's the name of the game. This is not extortion. I didn't say, give me $5 million and I won't out you. At the end of the day, the challenge is this. Now the man's about to be screwed. We all about to find out who it is. So I'm going to be staying tuned all the time. So it looks like now he done pissed off Buzbee. So Buzbee's about to file the lawsuit, include him, name him, whereas in the California lawsuit for extortion, this man has filed himself as a John Doe. So we don't know. Oh, great question. Abita says, is Buzbee making people pay to not reveal their names? Absolutely. That's what he's doing. My question is, do you guys think that that's ethical or that it should be fair? The issue is this: as long as you're telling the truth, you as a lawyer, that you feel that you're telling the truth and that what they did does rise to an actionable civil complaint, then you can do that. The problem is, if the claim is simply, let me just throw out a name. I'm not even going to throw out a name because I don't want people to misunderstand. But let's just assume Mr. Super Celebrity was simply there while other people, drank drinks that then made them drunk and made them do wild, freaky stuff. If you don't have any strong proof based on a preliminary research that us lawyers are required to do before we file suit, and we don't have any proof that, let's say it was Pharrell, that Pharrell knew these other people were being slipped Mickeys, or that they knew that these other people were being taken advantage of. You can't say, I'm going to sue you for being there. That's not a crime. But what's not clear is it sounds like for some of these people, that may be exactly how Buzbee is teeing these things up. Is it illegal though? Sounds unethical. Is it illegal though? So extortion is, and hold on, I'm gonna just put the definition on the screen. We're gonna put it up there. Extortion. So the answer is, as long as you're not lying, it's not illegal, is the gist. Here you go. Extortion is a practice of obtaining something, especially money, through force or threats. The problem is he used bribery and extortion to build himself a huge art stuffed mansion. The problem is when it's something truthful, you actually did the thing, it's not extortion. What would be extortion? So the perfect example is they say, I don't think you assaulted my client, but we're going to sue you for it if you don't give us $10 million. That's extortion. Like, and you don't even have to say, I don't think that you did it. If you've done a preliminary thing and you're like, wait a minute, a simple due diligence search would have been like, no, this person that I think it was the aggressor was actually out of the country touring, could not have done it. But if I didn't do that due diligence and I say, well, if I just filed this lawsuit against you, it's going to ruin your career and you're going to lose all your endorsements, that would be extortion. But if Tony Buzbee has done a thorough investigation of the facts and feels like, no, I really think you did that, giving someone an opportunity to settle out of court is perfectly fine. Because think about it. Cassie did that with the hotel where she got that televised beating that unfortunately we all sue across America. Same thing was under them. Cassie's lawyers sent a demand letter to the hotel, said, we've got this footage and we've got evidence that you concealed and obstructed justice by hiding this evidence, because that's a crime, that you were aware of how she was beat. And if you don't settle with us, either through mediation or otherwise, if you don't settle with us, we're going to let the world know your stock price is going to tank and no one's ever going to want to stay at the Hotel Intercontinental in life. And guess what? They got their money. They got that money. Great point. Abita says, it sounds like you could threaten someone with the truth. Basically, it's not considered a threat if it's the truth. Yeah. And here, Kenny says he's offering mediation to discuss it. I think that makes it ethical. I agree. Mediation, because here's the beauty of a mediator is mediators are usually former judges. So they go in and they tell each side, hey, look, this is the most risk that you're probably facing if we don't get this resolved today. So I also think saying, if you don't do this, I'm going to mediation, does not rise to the level of extortion. But to say, if you don't do this, I'm going to the cops, that's when it rises to mediation. Because here's the thing. If it's a crime, it's a crime. But you don't say, give me money so I don't report this crime. That is what would make something extortion. But to say, give me money and I won't file the lawsuit. Well, you're not filing the lawsuit because it's settled. You settled it. That's completely different than saying, give me this or I'm going to get you locked up and sent to jail. All right. So let's go on down to the next case. All right. The next case related to this is still Diddy. We're still talking Diddy. Let me go ahead and put this banner up for the docket. This is Diddy cell search. Y'all. So basically, Diddy's cell was searched and his lawyers are livid. So the gist of what happened is that, and I'm gonna put the letter on the screen. We're gonna go through the letter from his lawyers. And hold on a second. Before I get to that, does any of that money go to the clients? E. Peters? Yes, it does. I'm glad you asked. So here's how it works with Tony Buzbee's clients. Tony Buzbee's contract, and this is tea that you're going to get here, legal tea you get with your legal bestie. Tony's Buzbee's contract, because I've seen one before, is that he receives 33 1/3 if he resolves your lawsuit prior to filing a lawsuit. Now, if he has to file a lawsuit to get you justice, it goes up to 40% plus his expenses. Expenses would be depositions, document requests, travel. A lot of these attorneys, they have their own private plane. So they will literally bill the time on their private plane, handling your case, flying from one city. Maybe he's flying to New York to attend a hearing. All those expenses come out. Off top, he's going to get 40% because here he's had to file lawsuits against all of these people. But I'm also glad that you asked me about that, because that brings me to a good point about the so-called extortion, which is this. Because standard attorney contracts, when we take your case on contingency, say we get 33 1/3 or we get a lower amount if we resolve it without having to file a lawsuit, we have a legal obligation to try and resolve it without filing the lawsuit. So let's say it's $1 million case. If I get this resolved at mediation, which is what Tony Buzbee said he was trying to do, it means as a lawyer, my attorney fee would be $333,000. If I can't get it resolved at mediation, it means my lawyer fee is $400,000, assuming it's $1 million settlement. So you see what I'm saying? So that's why he actually did the right thing by sending the demand. The only thing that would be a problem is if the demand was full of lies, or he doesn't believe the person actually did whatever it was. And there's no way an attorney like Mr. Buzbee would file that kind of a lawsuit. Yeah, Buzbee is absolutely rolling money. How can one person be so corrupt? So yeah, so the clients get either 60% minus fees, minus expenses, or they get 2/3 basically minus fees. The fees always have to come out. And in a case like this where everybody is suing the same person, what's good about going to the same lawyer is you split the fees. So for example, there's probably going to be there could be one deposition of Diddy. In that one deposition day, maybe they go through each of the cases. You're going to be able to split those deposition fees, those court reporter fees, that kind of thing. Can the client recoup the money by suing the defendant? No. You've already sued the defendant. So yeah, but so the alternative is this. So some people are like, oh my God, the lawyer takes all the money. Here's the alternative. The lawyer is also taking all the risk. It could take 5 years to get this settled. And the lawyer we pay for our staff, we pay for depositions, we front all of the costs. If you need to go to therapy, we pay for your therapy, we pay for everything with the risk that we're not even going to win. So, yes, we're talking lawyer fees for Tony Buzbee. What I was saying is Tony Buzbee charges these people 40%. It's approximately 40% is what he gets off the top of any settlement if he has to file the lawsuit. And for these, he already has. If he doesn't file the lawsuit, he gets 33 1/3. Would I have ever taken on any of these cases against Diddy? That's the kind of case that I would take behind the scenes. And I would be part of the legal strategy team behind the scenes, but I would not do it up front. For a few various reasons. It can be very limiting. It's also going to take years. So MD said, I want to know who it is. And the client said, okay, lawyer's fees. All right. So now let's go on back. Now we got the new claim. So here's the letter from the government. So this morning, baby, the government was hot. They was mad. They're mad because the government is basically claiming that Diddy, there we go. The government is basically claiming that, Diddy's lawyers are claiming the government came in, searched Diddy's cell, took privileged documents. Now, privileged documents means documents that should only be seen by the lawyer or the client and should never, ever, ever be seen by the government because these are documents that are used to develop strategy. So an example of that would be potential witness list. So if you are on the defendant side, you don't ever want to share the potential witness list until it's time for trial. There are certain specific dates when you have to do that. But what happens is I would always tell my client, give me a list of who you think would be a good witness for your side. Then I'm going to send the private investigator to go speak with that person so we can confirm, are they actually going to say something helpful to your case? By the other side, getting a list of those people, it can really screw your case. Because let's say we go interview those people and those people decide they're not going to say something helpful, that they're going to say for you, it's going to be helpful for the state. Oh, shoot. Now you've given the state a helpful witness. So that's how come it's really important that if something's attorney-client privileged, it does not get shared with the other side. So here's the letter. Let's see if I can put it. All right. It says defense counsel has... move this banner off. It says defense counsel has recently learned that the prosecutors are in possession of attorney-client privilege material, including the defendant's own written notes. And you guys, part of the challenge is that what they're ultimately trying to set up for, Diddy's lawyers are trying to set up so that there can be a mistrial or this case can be dismissed against him, claiming that basically the state is behaving in a corrupt way. And or they want to use this to set up why it is he should be given bail, because they want to be able to say, hey, Your Honor, you got to give this man bail because he don't even have any privacy in his cell where he can properly prepare his case because they're taking evidence that he's collecting in his cell and giving it to the prosecution. That is an excellent argument for bail release, but we're going to get to the bottom of this and we're going to see why I don't think it's going to work. All right. So it says defense counsel recently learned the prosecutors are in possession of attorney-client privilege material, including the defendant's own written statements. This search and seizure is in violation of Combs' 4th, 5th, and 6th Amendment rights. Moreover, the targeted seizure of a pre-trial detainee's work product and privileged materials created in preparation for trial is outrageous government conduct amounting to a substantive due process violation. Because the prosecutors are currently in possession of privileged material and are actively using the material to detain the defendant, the defense requests an immediate evidentiary hearing. This is an emergent matter, meaning it's urgent, because the government has Mr. Combs' privileged notes to his lawyers concerning defense witness and defense strategy. The government's opposition to defendant's bail motion states that the trial prosecutors are currently in possession of, quote, possibly privileged materials, such as the notes recovered from the defendant's cell. In fact, the government is in possession of written material that is absolutely privileged. This is a matter of grave concern that most respectfully must be addressed immediately for the following reasons. First, there's no dispute that the government is in possession of privileged material because they're saying whatever it is something that was supposed to be for his lawyers. Second, until receiving the government submission at 11:29 Friday night, the defense had never been told that one, Mr. Combs' notes were taken from his cell, two, that these notes were given to the U.S. Attorney's Office, and three, that these notes were then given to the trial prosecutors in this case, who then used this material in a filing to keep Mr. Combs detained. So they use this as part of their motion. There's going to be on the 22nd of this month, there's going to be a hearing, another bail hearing to see if he should get bail. And they use what they got from the jail cell in that motion to say, no, he still should not be given bail, Your Honor. It says, we request an immediate hearing at which the government shall provide answers to the following. I want to hear these answers too. First, who authorized a search of Mr. Combs' sleeping area, personal effects, and paperwork? Sir, do you know where you are at? You are at jail. You are at jail. That's what happens. They search cells all the time. And I guarantee he's probably was not the only person that was searched. It was probably something going on at the jail. That jail is horrible. They have shakedowns all the time. Then it says, second, who determined what paperwork to take? Again, they probably collected everything as part of the evidence and then went from there. Third, who decided to give this paperwork to the U.S. Attorney's Office? And then fourth, who decided to give this paperwork to the trial prosecutors? Fifth, who made the decision to not tell Mr. Combs' counsel that the U.S. Attorney was in possession of his notes, including possibly privileged materials, until after the government put them in a filing to keep him incarcerated? Six, exactly what material was taken. Because the U.S. Attorney and it seems trial prosecutors are currently in possession of privileged materials, we request a full evidentiary hearing as soon as the court can accommodate us. It also says at the bottom, to the extent that a taint team provided attorney-client privilege material to the trial team without so much as notifying defense counsel it was in possession of his notes and work product, the defense may, after necessary fact-finding, argue against the integrity of the taint team process in this case. All right, here's what a taint team means. Taint team simply means, like, what'll happen is when you collect evidence, so there's something called discovery. This is the discovery process. What happens in discovery is you have lawyers whose sole job is to determine if anything that was collected was privileged. If it is, it goes into a pot over here to the left and is not shared with the litigation counsel, right? Because it could be privileged. So the taint team would be a team that goes through and says, oh, wait, these things could be privileged. We need to make a ruling and not share these. So basically, that's the team that protects this from not necessarily being a mistrial. Let me look at some of the comments. Somebody said, I'm so ready for him to go to trial. He probably got a PPP loan. Heck, he's done everything else. It says, that's crazy. They shouldn't they have been looking for dangerous things, not looking at notes and journals? So I'm so glad you asked that. The answer is when, like here, one of the large claims, the claim that's keeping Diddy in jail and not at home on bail, like, you know, the Abercrombie man who was over there making people pull out the dick. That's what the Abercrombie man was making people do. But yet he was able to go home on bail. The sole difference is obstruction of justice. So the allegation is that Diddy, even from behind bars, was paying witnesses not to say certain things, was like telling people, he was making three-way calls. Oh, it's a whole shebang. I'm gonna read it to you. So the issue is that what happens is when they shake down your cell, even when you get mail or anything, when they shake down your cell, they will look for any evidence that you might be tampering with witnesses. That's not unusual. And then here, what I'd like to know is how they're saying, well, why didn't you tell the defense counsel? That they filed it in that public motion on Friday. That probably was them telling it. So the question is going to be, how long did they have the information before they told defense counsel? Because one, you can have it, and number two, you may not realize it could be potentially privileged. So if they got it that day or the night before, it wouldn't be a problem to file what they filed in the court, because they clearly weren't hiding it, in that the document, the letter that they filed said, we are in possession of potentially privileged material, which we will share with the other side. And then it says they didn't take the notes. The team did the sweep, took the photos. Exactly. So let's go over the letter. This is a response from the state. And this is how the state is saying, shut up. The state is saying, you don't even know what you're talking about and you sound stupid. That's the gist of what the state's saying. So it says background. On or about, well, it starts, the government respectfully submits this letter in connection with the defendant's letter dated November 18th, and in response to the court's order issued earlier today. Because earlier in the day, so this is why I hate litigation. When somebody asked me earlier, would I work on the Diddy case? The problem is, if you work on that case, you can't work on no other cases while you're working on that case, because Diddy's lawyers filed a motion around 9 a.m. Whatever time the court got that motion, they said that the government needed to respond by 5 p.m. So that means if you had a soccer game for your kids, you had anything else you needed to do in that evening, it wasn't going to happen. All hands needed to be on deck to draft this particular response we're fixing to read. So it says, the question is, did anyone hear anything about Diddy using a cell phone in jail and calling witnesses? Yes, and it's going to be addressed in this letter. It says, on or about September 16th, the defendant was arrested. The following day, the above referenced indictment was unsealed, and the defendant was presented and arraigned before the honorable judge, whoever. As part of the proceeding, the government moved for detention under the Bail Reform Act, finding there was no condition or combo of conditions that would assure the safety of the community. The judge denied bail. Following day, another judge, Judge Carter, heard the defendant's bail appeal, and after lengthy hearing, determined the government had proven by clear and convincing evidence that the defendant was a danger to the community and a risk of obstruction. It says, since being ordered detained, the defendant's communications. So this is what's critical. This is what Diddy has been communicating and saying to other people. What we're going over is the state's accusations of how Diddy has been obstructing justice and why they ended up getting possession of the so-called privileged documents at issue. And the reason these documents are important is that Diddy's team is going to use these documents to get bail and or try and get this case dismissed. It says, since being ordered detained, defendant has been held at the Metropolitan Detention Center in Brooklyn, MDC. With respect to inmate communications, all BOP inmates, including the defendant, are afforded the opportunity to confer with attorneys on unmonitored phone lines. So the unmonitored lines are the ones you use to call your lawyer. And that's so that you can have attorney-client privilege. It says other communications occur over BOP monitored phone lines and email as part of its general practice to screen monitored communications for content that could jeopardize the public or the safety, security, or orderly operation of the facility. So, for example, they use that to make sure you're not contacting your victim, that you're not trying to intimidate witnesses, that you're not trying to move drugs. Those are all the things that the communications are monitored for. It says BOP staff, including a particular investigator, has constantly monitored the defendant's communications on monitored communication channels, including monitored phone lines. This monitoring is independent of the case team. The case team are the people that are actually prosecuting him. So here it says the assistant U.S. attorney charged with the investigation and prosecution of the defendant, and is not done at the case team's discretion. And let me tell you about this. I'm going to read, and I want you to consider what the government is saying with a grain of salt. Here's why. So I used to do death penalty litigation where I would represent people that were on death row, or that were going to trial, and that where death was on the table. And I'll never forget, we had this client who had been on death row for like 20 years. It was Miller L. was his name. You can Google it. It's in the textbooks, literally, because it went all the way after we worked on the case, went all the way up to the United States Supreme Court. Because the issue in that case was that in Dallas County, Black people couldn't get a fair jury because they had a jury manual. So if you were a prosecutor, when they would train you on how to select your juries, they'd give you this little booklet manual that said, don't pick Black people, don't pick Chicanos, don't pick Catholics for your juries because they sympathize too much with defendants. And literally, they were showing in this manual how they would eliminate Black people from a jury. That absolutely happened to this man's jury. And so the Supreme Court awarded him a new trial after 20 some years. And what happened is when he was awarded the new trial after 20 some years, we were coordinating for him to actually make bail. There were volunteers who were pulling up money together for him to make bail. We had all the money together after this man has sat in prison for 20 years. And boom, the day after, this man don't get on the phone and was talking with his lawyer, not nobody else, with the lawyer. And the lawyer's like, hey, we got all the funds. We're excited. We can make your bail. We're going to post your bail tomorrow. Prosecutor has a hearing to get the bail raised. Miraculously. They never tried to raise that bail before. That's how I know they were listening to our phone calls. They were actually listening to the phone calls between between defendants and lawyers. So me, I was a young baby lawyer at the time. I might have actually still been in law school. And I was like, oh, we need to file a motion. We need to do all this. That's trifling. They can't do that. You know what the court-appointed lawyer said? I don't want to do that. I don't want to upset the judge. Bitch, what? What? That's when I realized the game. These poor court-appointed lawyers, that lawyer said, I don't want to upset the judge by filing that motion, because the judge appoints them to other cases, and that's how they make their money. So if you piss off that judge, you're messing up your own income stream. When I heard that, I was like, Lord, these people don't stand a chance. The question is, will the lawyer get in trouble for talking to the client on the contraband phone? Could be. Will the lawyer? Not necessarily, because actually the lawyer doesn't necessarily know that the phone is contraband. So I would say no, that wouldn't be what they get in trouble for. So all right, let's continue. It says, as set out in the government's November 15th brief and made clear on the record during the previous bail hearings, the government's grand jury investigation of the defendant, including the defendant's obstruction related to this criminal case, is continuing. As part of that investigation, the government has sent grand jury subpoenas and doc requests to the BOP for the defendant's monitored communications, including calls and emails. In other words, because we're charging him with obstruction of justice, we're requesting these communications to prove the obstruction of justice. Obstruction of justice means tampering with witnesses and stuff. It says, from those materials, the government has learned the defendant has persisted in engaging in obstructive conduct since he entered BOP custody. Among other things, the defendant has engaged in unauthorized communication practices, including number 1, three-way calling on the monitored phone line. So that's like he has permission to call Quincy, and then he has Quincy call in one of his fixers. Okay, I'm not saying that's exactly what happened, but that's an example. Number 2, use of other inmates' phone access. That was interesting to me because that means he's communicating with other inmates. I thought he was literally like only in his cell, no one else around for his protection. The problem with using other inmates' access cards is because they can't track your communications. They need to do that to make sure you're not tampering with witnesses. And it's completely against the rules to use other inmates' phone access card number. Hello, Simone, how are you? Hold on one second. Hold on one second. Give me 1 second. Hold on, y'all. I got 2 screens up. Hold on. I have to come off this one because I'm still wrapping up my live, guys. Okay, there we go. All right. So then it says here, the number 3 is almost done, y'all. The third thing it says he's done. Wait, did I just switch? Hold on. There we go. And number 3, use a third-party text. What is this music coming from? Can y'all hear this music? What the the hell? Hold on, y'all. It's Christmas music.
I got your card.
Oh, really Lord.
Appreciate the invite, Aunt Dora, but
there we go. Sorry. I don't know where this Christmas music is coming from. Apologies. But it's saying the number 3 thing that he did was use a third-party text messaging provider through the BOP's monitored email line, email system. So in other words, it appears that he's trying to hide communications. And it says each of these communications is prohibited. So the number 3, that might be where people are getting the idea that he's using a cell phone without permission. Use a third-party text messaging of a third-party text messaging provider through the BOP's monitored email system. It says, furthermore, as set out in the government's brief, the defendant used these unauthorized methods of communications to continue to engage in obstruction, including by instructing third parties to reach out to witnesses and attempting to influence the jury pool in this criminal case. So attempting to influence the jury pool is huge. We all know that that's a huge problem. There we go. Because everyone keeps talking about how, oh, well, are the other lawsuits that people filing, is this impacting the jury pool? Is, what the prosecutor's doing impacting? At the end of the day, his conduct, if he's doing certain things, can impact it just as well. It says the defendant has used all 3 of the aforementioned methods of communication to communicate with his lawyers. Accordingly, although it's clear to all parties involved that these calls and emails are monitored in an abundance of caution, the government sent any potentially privileged communications, which means anything involving a lawyer, to the filter team for review before it was released to the case team. So basically they're saying, hey, this is how we covered our butts. There shouldn't be a mistrial, because what they did is they said, we didn't read them. We sent it to the filter team. And it says, such as the investigation, it says, as is the government's longstanding practice in ongoing covert investigations, such as the investigation into the defendant's obstruction conduct in the MDC, basically how he's been obstructing things from behind bars, the government did not disclose potentially privileged communications to the defense counsel at first. In other words, we got an investigation going. We're not about to play with y'all. We're going to do our investigation. And then once we've done that and we've decided, like, if we're going to use any of this to press charges, then we're going to let you know. We're not about to give you this information so you could keep obstructing justice, dummy. Then it says, as stated in the government's opposition to the defendant's bail motion, the government intends to produce all the defendant's calls and emails in full to the defense counsel today. In other words, hey, we got this remedy. You're going to get everything today, which is the 18th. Hearing is on the 22nd. Let's talk about it then. Now, here's how the sweep of the MDC even happened. It says, on or around August 28th. Okay, so what was that? It's about 2-3 weeks ago. The BOP and several other federal and local agencies initiated a sweep of the MDC. The sweep was pre-planned and coordinated to ensure the safety and security of staff and inmates at the MDC, and was part of a larger safety and security initiative. It was not in response to any particular threat or intelligence. In other words, they didn't do this just to piss off Diddy. It said the MDC sweep, including the jail and the warehouse where MDC food and other property are served. It was planned well in advance of the defendant's arrest. It was not conducted to target any particular inmate, including defendant. During the sweep, multiple housing units were searched, including the defendant's unit. Although members of the case team were aware, case team is the government people that are specifically prosecuting him. Although members of the case team were aware in advance that the defendant's housing unit would be searched, no one on the case team supervised, conducted, or participated in the search of any housing unit, nor the search of the defendant's bunk area. In fact, the case team was not aware in advance of what agents and officers were conducting the search of that housing area. So basically, they didn't even know. So shut up. Investigator 1 was assigned by BOP to participate in the week-long sweep and was present at the MDC during the operation. During the sweep, the defendant's housing unit, Investigator 1 interviewed multiple inmates, including the defendant, about potential corruption and contraband. Following his interview of the defendant, the investigator approached the defendant's assigned bunk to check for contraband. On his bunk, he found the following items: a manila folder marked legal, a notebook labeled, I think it was labeled things to do. And that's because there's a footnote here. Where's number 2? There's number 2 footnote. One footnote. There's a footnote here It says, for reference, the government is including as exhibits photographs of a notebook labeled Things to Do and the address book as Exhibit A, which contain redactions per the filter team. This is the full set of material from the BOP sweep that was provided to the case team. This exhibit is being filed under seal pursuant to the protective order. All right. So we got the Things to Do book. I want to know, what things do you got to do, sir? You are in jail. Brush your teeth, wash your hair, like brush your teeth, wash your armpits. It also had an address book and personal effects. Investigator 1 felt the outside of the manila folder marked legal for contraband, feeling none, set it aside, didn't open or photograph it. With respect to the notebook labeled, I think that means Things to Do because they said it below, and the address book, Investigator 1 took photos of these materials. Investigator 1 left the materials on the defendant's assigned bunk. No physical materials were seized from the defendant. Stupid. Just kidding. Following the MDC sweep, Investigator 1 alerted the case team he had taken photos of the defendant's Things to Do notebook and address book. Investigator 1 described the Things to Do notebook as largely notes to self, which makes sense. Things to do in your jail cell or whatever. Written by the defendant that included notes regarding something or another. In an abundance of caution, the case team asked Investigator 1 to provide the photographs directly to the filter team, given the possibility that they touched on legal strategy. Following a review, filter team provided certain of the photographs to the case team. That means after it was determined that they were not privileged, including photographs, including redactions. Now, this motion, it's saying, on November 8th, defendant submitted a renewed motion for bail in front of your honor. The government's response, filed on the 15th, argued, among other things, that the court should deny defendant's motion to reopen the bail hearing since he had failed to present any new or material information. In addition, the government has argued the defendant was actively continuing his efforts to obstruct justice while in custody, including by, among other things, attempting to influence witness testimony. In support, the government cited to excerpts of portions of the photos that discuss the defendant paying a potential witness and blank on other potential victims and witnesses, which had been provided to the government after a review by the filter team. In other words, they did what they were supposed to. They filtered, and when they filtered, what they found is this man's out here paying witnesses. The one of the witnesses that was allegedly paid, it was alleged that I think it was $100,000 was paid to Kalina to say she don't know what Don Richards was talking about, conveniently. So that payment was made on the same day that Kalina made a public statement that, like, she's never seen Diddy do anything. She doesn't know what Don is talking about. Girl, I bet you don't. It says on November 18th, defense counsel submitted a letter motion to the court arguing the government was in possession of attorney-client privilege material, namely portions of the photos which reflected the defendant's notes, which it argued were privileged notes to his lawyers concerning defense witnesses and strategies. Defense also argued the government had engaged in a targeted seizure of the defendant's materials, which it argued amounted to a violation of the defendant's rights. Defendant therefore requested the court hold a hearing to assess, among other things, who authorized the search. It says, as discussed, there was no targeted seizure of the defendant, and the BOP sweep resulting in the government's obtaining the photographs was not unconstitutional. In other words, as long as you were in that facility, your cell got searched, and the sweep included you. Okay, now it says relevant law. I'm going to just skip to the most important parts. This is, in accordance with the policy, staff may search an inmate's housing and work area and personal items contained in those areas without notice. You're not going to give somebody notice. If you're looking for contraband, you're going to be like, well, guys, I'm going to come look for that contraband at 3:00 today. Of course not. And it says, indeed, even when a prison regulation impinges on inmates' constitutional rights, a regulation is valid if it is reasonably related to legitimate penological interests. I don't even know what penological means, but it probably means legitimate interest of the penal institution, because I took Latin. All right. Accordingly, although pretrial detainees may have some residual privacy interests that are protected by the Fourth Amendment, courts must weigh those interests against the requirements of preservation of institutional security and order. I'm sorry, I'm just very impressed that my Latin, hey, Miss Hinkle, my Latin 4 instructor, my Latin really came on in there, so that now I know what penological interest means. It means penal institution interest. All right. Next it says, When potentially privileged materials are obtained by the government, the use of a filter team is a common procedure in this district and has been deemed adequate in numerous cases to protect attorney-client privilege. One example is a quote from this case that says, "The government establishes an effective firewall to prevent disclosures to the government's trial attorneys of trial strategies or confidential information between the defendants and their attorneys." Um, and so then in their discussion, they explain, I said, here we go. It's pretty brief. They said, first, the fact that the photographs were taken was proper, entirely proper. They were taken during a pre-planned sweep of the MDC, which was organized, initiated, and executed by POP staff. Then it goes on to say, nor is there anything improper about Investigator 1 taking the photographs. Investigator 1, who had reviewed the defendant's calls and emails in which the defendant overtly and persistently engaged in conduct that violated BOP rules and regulations, was entirely justified in inspecting the defendant's assigned bunk to recover additional evidence related to those violations and to ensure the security of the facility. Moreover, Investigator 1, who is not even bound by any privilege doctrine that may affect the case team, he took steps to respect the potential privilege of the defendant's effects. Specifically, he did not examine the manila folder labeled legal. He confined his review of materials to the notebook labeled things to do. Moreover, none of the steps taken by the investigator while he was searching the defendant's bunk were done at the case team's discretion. And second, government's use of the filter team to review the photographs in the first instance is entirely appropriate and adequately protects any potentially privileged documents. And I'm going to jump down. Finally, the photographs and what's depicted in them are not privileged. That's the truth. The defendant doesn't argue, nor could it, that the notes in the photographs were prepared for the purpose of obtaining legal advice. Here's the thing. The only things that are privileged is if me as your lawyer, if I say, hey, I need you to, here's some homework. I need you to come up with a list of such and such. Give me information on this. Summarize. Give me a timeline. Those things are privileged. So it has to be something your attorney has instructed you to do, or that is being done specifically for the purpose of legal strategy or case preparation. You just jotting down things to do in your jail cell because you're bored isn't privileged. And it says, even if there was disclosure of privilege, let's say, contrary to defense counsel's mischaracterization, the photographs do not reflect notes to the defendant's lawyers concerning defense witnesses and defense strategies. Rather, the photographs depict the defendant's wide-ranging notes to himself, including notes related to the defendant's business interests, his release of music. Diddy is over here trying to release some music from this jail cell, y'all. His release of music and family matters, among other things. Under the law, these sort of notes are not protected by the work product doctrine. And even if there was disclosure of privileged material to the case team, that alone is not a basis for the relief defendant seeks. Basically, he's trying to get out on bail because they done snatched up some pictures in his things to-do list. It says, indeed, in order to be entitled to a hearing to determine whether the prosecution was tainted by exposure to privileged information, defendants have the burden of showing a factual relationship between the privileged information and the prosecution. So, for example, if they got information that says, oh, I once confessed such and such to this witness, and you, my lawyer, I want you to know this, that's something that could be directly tied. But this stuff they're claiming is not specific. It said the defendant has not done so here, particularly given the government's good faith use of a filter team. And then at the bottom, it says, it is well established the work product privilege does not apply to documents that are prepared in the ordinary course of business or that would have been created in essentially similar form, irrespective of the litigation. So that things to do list, he was going to be doing something in that jail cell. So they're saying that specific. Also, if you're just drafting documents, like if you're just sending a letter, let's say he wants to write a letter to his kids, that's not considered attorney-client privilege. That's just something that he's done in the regular course of sitting in his jail cell. So let's hit that like button up. Kalina from Dirty Money. Yes, Kalina is hungry for dirty money. Ooh, that's true. The feds legally said y'all are reaching. That is right. So I guess overall, the takeaway Oh, thank you. Overall, the takeaway is that I don't think that this is going to rise to the level that, I mean, it's a try, but it's not going to rise to the level that Diddy's lawyers want. It's not going to get him bail. If anything, this back and forth argument is probably going to cause him to not get bail. Because if it is shown in this bail hearing on the 22nd that he's been tampering and doing the things that they've argued, oh, he's in for a long ride. Blue Neptune, thank you. It says, oh no, the title says Daddy's lawyers sue. Oop, let me edit that. See, this is why I should have been looked at that. Damn, autocorrect. Thank you. Okay, got it. Oop, hold on. There we go. Thank you so much. Well, it's not letting me do that now. There we go. Okay, it just fixed it. But I also want to be clear. Here we go. The physically said y'all are reaching. Yes. Over 50 rapper super chats and has yeah, I think Kalina says, yeah, Kalina, I think Kalina is broke. I think Kalina needs some money. And I mean, there's honestly, if somebody was willing to cut me a check for $100,000 with my panties on right now, and I don't have to take them off, there's a lot of things I would consider doing. There's a lot of things. And if that 100,000 also meant that this man would stop calling my phone 154 times in 1 week, I'd probably cash that check. I'd probably take those funds too, which is what she did as well. But I think overall, many people, their concern with this motion and what's going on here, their concern is that did the government misstep in such a way where Diddy might be able to get off? And I don't think that's the case here. However, one of my concerns is that with regards to Trump, I want to know to what extent might he or does he have the ability, and I'm going to need to talk to one of my peers about this, would he have the ability once he becomes the president to force them to give Diddy bail? I don't know. I know he can pardon, but I don't know that he has the ability to force them to give him bail. But I also know he would probably love to pardon Diddy because he loves S abusers. He'd probably love to do that. I don't think he's going to do it at the beginning of his term, but I do see him doing it towards the end because at the end, it's what's called a lame duck presidency, meaning there's nothing that can be held from you. He can't run again. But what he does like to do is make a name for himself. And he likes to be contrary. So I think it really just depends on how much Diddy's lawyers stroke and affirm Trump because he's not that bright of a person. So I could absolutely see Trump pardoning him. Especially because the majority of his victims are brown, and we know Trump don't like brown people. Forget about it. So hit that like button. Oh, that's right. Diddy did talk junk about him. See, that's going to be the issue. Yep, you are right about that. So I guess his lawyers, but it'll probably be the lawyers' relationship to Trump, greasing his palms, things like that. And at this point, we know Diddy has 50 million that he's willing to put up for whatever. I could see Trump changing his mind for 50 million. Trump will buy a pardon. And then he'd be like, well, I did this in my presidential capacity. The Supreme Court has already said I have immunity for anything I do in my presidential capacity. And boom, he could very well get away with it. So thank you guys for joining. This is Girl Is That Legal, your legal bestie, Attorney Simone. And please stay tuned and let me know in the chat below what other cases and controversies you want me to cover. Have a great night.